Hello everyone and welcome to the October 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on September 19, 2025. Of James Bowles versus Citizens United Reciprocal Exchange et al. The second case law update is on the unpublished opinion per curiam of the Court of Appeals that was issued on September 18, 2025 of the consolidated opinion of Miracle Hands Homecare Inc. versus Geico General Insurance Company and Jorge L. Fuentes and U.S. Rehabilitation and Health Services and Geico Insurance Company et al. Lastly, we will focus our discussion on a trending topic of PIP litigation pertaining to the fee schedules contained in MCL 500.3157, most specifically the recent to-be-published decision of the Michigan Court of Appeals of Angelo Favot versus Jimarion Brown et al., issued on September 18, 2025, came down, and we will discuss that. As we will discuss in detail, the court's decision in this particular new opinion is notably very similar to the court's 2024 holding in Central Home Healthcare Services, Inc. versus Progressive Michigan Insurance Company. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on September 19, 2025 of James Bowles versus Citizens United Reciprocal Exchange et al. This case discusses policy rescission based on fraudulent misrepresentations relating to ownership/registration of vehicles on the policy. In December 2021, plaintiff applied for a policy with defendant Cure for a 2016 Lexus and 2010 Mercedes-Benz and was granted the policy the next day. Plaintiff was involved in a motor vehicle accident with another defendant named in the suit, Arnell Stokes, while driving the 2016 Lexus insured under the Cure policy. Plaintiff filed this PIP action against defendant Cure in June 2022. Defendant Cure discovered during this litigation that plaintiff had materially misrepresented sole ownership of the two vehicles on the insurance application when, in reality, his daughter held the title to the 2016 Lexus involved in the accident, and the 2010 Mercedes-Benz was registered to Motor League Sports Academy. In turn, Cure argued that plaintiff's policy should be voided ab initio as a result of plaintiff's fraudulent misrepresentation. Cure further presented a signed affidavit from Cure's underwriting manager, who stated that had Cure been aware of this misrepresentation, it would not have issued coverage for the vehicles. Plaintiff's argument in rebuttal was that Cure failed to meet its burden of proof as to several elements of material misrepresentation. Plaintiff asserted that he did not knowingly misrepresent anything on the insurance application because the alleged misrepresentation had nothing to do with the title holder of any vehicle. Contrarily, the application asks only whether the vehicles are solely owned by and registered to the applicant. According to the testimony of plaintiff and the title holder, plaintiff was and always had been the sole owner and registrant of the Lexus. The trial court ultimately sided with Cure, deeming the insurance policy at issue void ab initio, and dismissed plaintiff's claims with prejudice, and this appeal followed. The Court of Appeals also found plaintiff's argument to be disingenuous. At the very least, the available evidence demonstrates no genuine issue of material fact. The plaintiff knew he was not the sole owner of either vehicle. While plaintiff may have made payments on and registered the 2016 Lexus, his daughter not only signed the loan to finance the purchase of it, which left her responsible for any default in payments, but also exclusively held title to it. The court concluded that, viewing the evidence in the light most favorable to plaintiff, the No-Fault Act's definition of an owner, along with plaintiff's deposition testimony that his daughter signed the loan for and held title to the 2016 Lexus, and that he once owned the 2010 Mercedes, but switched ownership of it in 2018, showed he knowingly misrepresented sole ownership in the vehicles. The court also rejected plaintiff's challenges to the trial court's findings as to the materiality of the misrepresentation and the injuries suffered as a result of it. As to plaintiff's evidentiary argument based on MRE 1002, he did not cite to any case law holding that insurance underwriting rules constitute a writing under MRE 1002, and the court found none. Most importantly, the court noted that, quote, an insurer's statement that it would not have issued the policy had it known the truth of the vehicle's ownership is sufficient to establish the materiality of the misrepresentation, unquote. Lastly, the court notes that Cure suffered an injury when it unknowingly assumed an underwriting risk it would not have had the plaintiff been forthright as to the vehicle's ownership. The second case law update I have for you is on the unpublished opinion per curiam of the Court of Appeals that was issued on September 18, 2025 of the consolidated opinion of Miracle Hands Homecare Inc. versus Geico General Insurance Company and Jorge L. Fuentes and U.S. Rehabilitation and Health Services and Geico Insurance Company et al. This lawsuit relates to the retroactive application of the no-fault fee schedules of MCL 500.3157 and a motorcycle accident. This case arises out of a motorcycle versus motor vehicle accident that took place in September 2019, in which plaintiff Fuentes was seriously injured as a result while riding his motorcycle. The vehicle involved in the accident was insured under a policy issued by Geico. Fuentes was not a party to the policy, and the policy made no mention that its coverage applied to motorcycles or motorcyclists. As a result of the accident, Fuentes received in-home care from plaintiff Miracle Hands between August 2020 and February 2022. The parties could not ultimately agree on the applicability of the fee schedules, so Miracle Hands ultimately filed suit seeking to collect payment of PIP benefits as to its bill, and Fuentes also filed his own PIP suit. The trial court ultimately applied the fee schedules to treatment rendered after July 1st, 2021. On appeal, the Court of Appeals rejected plaintiff's retroactivity argument under Andrew 2, explaining that Andrew's bar turns on whether a claimant has both contractual and statutory PIP rights. The court pointed out that Andrew 2's ban on the retroactive application of the fee schedules in MCL 500.3157 depends on whether a plaintiff has both a statutory and contractual right to claim PIP benefits. The court next rejected the contention that accidents before July 2nd, 2020 are exempt from the fee schedules, noting that unlike MCL 500.3107C and MCL 500.3107D, the text of MCL 500.3157 does not distinguish the fee schedule's applicability from the policy's effective date and merely details the amount of payment owed for treatment rendered after July 1st, 2021. The court notes that reading in a date limit, quote, would run counter to our canons of statutory interpretation, unquote. Finally, the court rejected Fuentes' third-party beneficiary theory, relying on the case of Harris v. Auto Club. The plaintiff in Harris was neither a third-party beneficiary nor a subrogate of the no-fault policy. Rather, that plaintiff's right to PIP benefits arose solely by statute. MCL 500.3114 subsection 5 does not give motorcyclists a contractual right to recover PIP benefits from an insurance policy. It only provides a statutory right to make a claim for PIP benefits from specific insurers. The court ultimately affirmed the trial court's decision applying the fee schedules to treatment rendered after July 1st, 2021. Finally, I wanted to discuss the trending topic in PIP litigation pertaining to fee schedules contained in MCL 500.3157. Most specifically, I want to discuss the recent to-be-published decision of the Michigan Court of Appeals of Angelo Favot versus Jimarion Brown et al. Issued on September 18, 2025. As we know, since the implementation of the fee schedules contained in MCL 500.3157 tied to Medicare reimbursement rates, providers have continued to routinely challenge, often successfully, the application of any Medicare text outside strict parameters of a Medicare fee schedule by using a narrow interpretation of the Medicare definition found in MCL 500.3157 subsection 15F, which specifically disallows an insurer from applying limitations unrelated to the rates in the fee schedule, such as limitation or supplemental payments related to utilization, readmissions, recaptures, bad debt adjustments, or sequestration. As I hinted before, the court's decision in this newer case is notably very similar to the court's 2024 holding in Central Home Healthcare Services, Inc. versus Progressive Michigan Insurance Company. In the recent opinion of Favot v. Brown set for publication, the Court of Appeals adopted and extended the reasoning behind the court's 2024 holding in the Central Home Healthcare case, which was handled by Secrest Wardle at the trial court and Court of Appeals levels, confirming additional limitations commonly used by Medicare are permissible to determine the maximum payment an insurer is responsible for. Together, Favot and Central Home bring a welcome framework for insurers analyzing when services are payable by Medicare and what provisions within Medicare are applicable in determining the maximum amount providers are to be reimbursed. The specific question in Central Home Healthcare Services, Inc. was whether the plaintiff's services were reimbursable under MCL 500.3157, subsection 2A, at 200% of Medicare, or MCL 500.3157, subsection 7AI, which was 55% of plaintiff's 2019 charge description master. The parties agreed Medicare reimbursed for the services by utilizing the prospective payment system rather than a Medicare fee schedule. Plaintiff argued the no-fault Medicare definition precluded application of fee caps with MCL 500.3157 subsection 2 unless the amount payable by Medicare was pursuant to the Medicare fee schedule. The panel adopted defendant's argument that the prospective payment system provided an amount payable under Medicare and that nothing in the definition of Medicare in subsection 15F makes the method of calculation relevant for determining the application of subsection 2. And in the recent decision in Favot, defendant argued that the trial court erred in denying its motion for partial summary disposition. Defendant asserted that there was no issue of fact that MCL 500.3157 subsection 2 allowed for the application of 3 Medicare limitations reducing the reimbursable amount, and that, therefore, prior payments were issued at the statutory maximum discharging defendant's liability. Defendant's position was the 3 limitations applied, package service rule, multiple procedure reduction rule, or MPPR, and billing modifiers, were related to the Medicare fee schedule and consequently not disallowed by the no-fault Medicare definition. Plaintiff's successful trial court argument was carried over, asserting the limitations were, in fact, unrelated to the fee schedule and therefore cannot be used to reduce the amount owed pursuant to the definition within MCL 500.3157 subsection 15F. The Court of Appeals opinion in Favot cited Central Home as the authority that the amounts payable by insurers are not determined by the rates in the fee schedule alone, but also by applying limitations related to the rates in the fee schedule. The pertinent question in the case was framed as whether the limitations defendant seeks to apply are of the same kind, class, character, or nature as the unrelated limitations listed in MCL 500.3157 subsection 15F. Analysis of the purpose and effect of all 3 limitations applied by the defendant in comparison to the specifically disallowed limitations listed in MCL 500.3157 subsection 15F ensued. The court noted the specifically excluded provisions listed in MCL 500.3157 subsection 15F were grounds for denying unreasonable expenses, providing avenues for hospital-wide reductions and reimbursements, not as to any specific charge, or related to nationwide cancellations and payments. In contrast, the court found the limitations applied by the defendant were directly related to the amounts payable by Medicare and were thus of a different kind, class, character, or nature. After distinguishing and classifying the provisions, the court concluded, under the plain language of MCL 500.3157 subsection 2A, limitations such as the MPPR, the package service rule, and the geographic billing modifier affect the amount Medicare would pay for the particular service, meaning they would be considered for purposes of the No-Fault Act. The Court of Appeals ultimately affirmed the trial court's decision in part, reversed in part, and remanded for further proceedings consistent with this latest opinion. That concludes the October 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topic in the PIP world. Take care, everyone.